We will now hear from Melissa Morgs with the Manhattan District Attorney's Office on Out of the Fry Pan and Into the Fire, How to Kiss Your Judge and Defend Your Forensic Technology in Court. Melissa, take it away.
I am told that many in the audience are forensic scientists as opposed to lawyers. Nobody graduates from law school knowing how to handle Frye challenges to forensic evidence. I have handled most of the Frye challenges for the Manhattan DA's office over the last decade, so my approach will be that of a prosecutor defending the use of forensic evidence in court. From my perspective, the one indispensable factor in defending any Frye challenge is the help of the forensic lab that did the work in the case. My approach is pragmatic. Teach the judge all about the science, because if he understands it, that's your best shot at getting your evidence to the jury. Copyright information and the views expressed are my own. Now, I don't know what life was like for any of you in high school, but as far as I'm concerned, science nerds are the ultimate cool kids. Frye and Daubert tests are somewhat different from each other. Frye determines general acceptance by counting and assessing the scientists who support the science. Under Daubert, a trial judge has a duty to scrutinize evidence rigorously to determine whether it meets the requirements of Federal Rule of Evidence 702. While we will be referring to the Frye Standard, the suggestions we have for putting together a Frye hearing will be applicable in both situations. We get Frye challenges to a wide variety of technologies. A representative list includes probabilistic genotyping software programs, serology testing, cell phone and cell tower location tracking, facial recognition software, ballistics firearm tool mark comparisons, latent print comparisons. We've had all of those in the past 2 years alone. To be sure, with the possible exception of the prob-gen programs such as StarMix, none of those technologies are new. What is new are the types of attacks we are seeing, many of which are based on some government-generated reports questioning forensic science, like the NAS report and PCAST, which we will talk about in detail a bit later. Instead of arguing that the entire discipline of firearms tool mark comparisons is unreliable, for example, the defense will argue that the error rate is too low because inconclusive should be counted as examiner mistakes. Or the defense will say that latent print examiners should not be permitted to testify to a match because there's no evidence that fingerprints are unique, or there's no minimum number of points required for a match, or the judgment of the examiner is subjective. Often the goal is to limit analyst testimony to say that the questioned shell casing or latent print cannot be excluded as coming from the known source. The point of the defense is to dilute the testimony so it becomes basically meaningless. While the overwhelming number of forensic tests passed Frye and Daubert, the U.S. Supreme Court determined that polygraph, lie detectors, do not have general acceptance. That case involved a soldier who was working as an undercover with military police in a drug investigation that was taking place on an Army base. He was required to undergo random drug screening and polygraph tests as part of his cooperation. One particular day, he gave a urine sample, and that same day he was polygraphed about drug use, and he denied using any drugs. Before his urinalysis came back positive for methamphetamine, he went AWOL, and when he returned, he faced a court-martial. The soldier challenged the accuracy of the urinalysis, and he wanted to admit results of the polygraph because the polygraph indicated that he was telling the truth when he denied using drugs. However, A section of the Military Justice Code Rules of Evidence said that no polygraph results were admissible for either side, no matter what the results were. The soldier claimed it violated his right to present a defense because he wanted those polygraph results in evidence. The court did a thorough evaluation of the scientific support for polygraph evidence, and it upheld the prohibition against admitting the polygraph because it said that polygraph evidence was not generally accepted as reliable. So whenever there's a Frye challenge, we have to fight back. Whether we just have to submit briefs or we end up with a hearing where witnesses testify, the quantum and type of evidence is the same. We have to educate the judge so he or she can understand how the science works and why it is reliable. The judge is not necessarily good at science because, let's face it, most of us lawyers went to law school because we were bad at math. If we had been good at science, we would have gone to medical schools like our mothers wanted us to. So we have to teach the judge. When I say we, I mean the lab experts and the prosecutor. It will be your job, either as the prosecutor or the lab analyst, to make sure that things are clear to the court. The defense will try to confuse things as much as possible, because if the judge is confused, the defense has won and we lose our forensic evidence. When we respond to a defense Frye motion, we want one thing. We want the judge to issue a written decision in which he basically cuts and pastes from your papers and your witness testimony, where he adopts your position and describes the science, recounts the expert testimony, and explains why the science is generally accepted as reliable. And because judges are generally free to rely on the admissibility rulings of other judges, assuming that the decision is based on sound principles, if you get one good decision, you may be good forever in your jurisdiction. I've seen that the general thrust of many defense arguments is that the lab has adopted some incredibly risky, unfounded, untested, vague, subjective, and unproven technology or protocols. We know that is simply untrue. Lab directors are very conservative in their science. They have to be. Money is tight. They have to beg the government for funding. They have to plan their budgets years ahead. They have to justify every expenditure. They have to comply with all kinds of accreditation requirements. This makes lab managers risk averse, and you should remind the judge of that fact. Another thing, lawyers who really understand forensics are thin on the ground. We are basically 100% reliant on the lab. So if you are the lab manager, if you are the lab expert who's going to testify, invite your prosecutors into the lab. Invite them to the DNA lab. Show them the instruments. Explain step by step how the analysis is done. Demonstrate the chain of custody. Point out where the evidence cages are. Show them how you bleach the tables. Show them how the LIMS systems work. Show them how reports get written. Show them how you calculate stats. Show them how technical review works. Lawyers, go to the latent print section of your police department. Look at the APHIS terminals. See how they work. Watch the examiner plot the minutia points on the latent print. Watch him do the side-by-side comparison. Watch him point out the points of comparison. Go to the ballistics lab and watch the examiner mount the shell casings on the compound microscope and look through that microscope yourself. Understand their blind verification system. If you do these things, if you have actual hands-on experience, if you see how this works with your own eyes, You will become a much more confident and persuasive advocate in court. If you are the lab witness, you want to explain the basics of the science to the court. Don't assume the judge knows anything. Literally, start from the beginning as though it was career day at your kid's elementary school. This is the keep it simple part. Why? Because we want the judge to understand the science well enough to explain it in his decision. And if you think I'm repeating myself, it's because I am. I'm a huge fan of visual aids, so you should create some for the judge to review after the hearing is over. And a lot of people are visual learners. It helps for someone to see a representation of a complicated scientific process. As part of your evidence of general acceptance of reliability, you want to establish that the lab is highly regulated. What kind of rules does the lab have to follow? Does the lab make it up as they go along? No, they don't. The lab is probably ASCLD or ANAB accredited. If it's a DNA lab, it follows FBI, QA, and QC rules. It follows CODIS rules. It follows SWGDAM and ISFG recommendations. Labs follow NIST and OSAC recommendations. They follow process maps. They follow AFTI and IAI procedures. They follow regulations promulgated by state forensic commissions. And they follow the specific protocols from your own particular lab. The court needs to know how all these regulations affect your forensic practice. Tell the judge about lab audits and inspections. Describe analyst training and the whole proficiency test system. Talk about nonconformities, how you catch and correct mistakes. If you are defending a new technology in your lab, say that you have adopted put StarMix online, or you are now using a confirmatory serology test like proteomics, it will be important to introduce evidence of whatever validation your lab has done. Lawyers and judges don't know what validations are or why labs do them. It's up to you to explain why validations are done, to prove that the lab methods are robust, that is, successful results are obtained a high % of the time, and few, if any, samples have to be retested. You want to show that the method is reliable, that you obtain accurate results that reflect the sample being tested. And you need to show that the method is reproducible, that the lab gets the same or very similar results each time a sample is tested. It's important to describe the validation and give concrete examples of the types, the numbers, and characteristics of the samples that you use. Explain why you use mock casework samples that are created by the lab so you know whether you get the right answers when you apply your technique or procedure. It's guaranteed that the defense will criticize your validation. They will argue that the samples don't actually replicate every single possible casework situation that might hypothetically exist. Fortunately, SWGDAM and ISFG have guidelines for DNA validations, what the validation should look like, how many samples should be used. So it's important to note that you follow them. For example, for a StarMix Frye response, we described the validation error rate, and it was very, very low. The judge cited that particular factor in his decision saying that we did not have to hold a Frye hearing and that he approved use of star mix in court just based on our papers. There are many studies which demonstrate very low false positive rates in some pattern comparison disciplines. For example, firearm and tool mark analysis. On the DOJ website, the Department of Justice in 2021 issued a statement on the PCAST report regarding forensic science in criminal courts, ensuring scientific validity of feature comparison methods. It's about a 10-page report, and attached to the report at the end is an Appendix A and Appendix B. And what those pages have is a complete list of firearm tool mark studies and error rates for those kind of comparisons. And the error rates are extremely low, almost vanishingly low. The false comparison rate is very, very low. So if you have that kind of Frye challenge, you are certainly going to explore those studies and the results with your judge. There is a similar number of studies showing very, very, very few false positive results in latent print comparisons. And I've provided a list of the studies. They're relatively easy to find either in the journals or in the on the PNAS website. Again, if you are facing a challenge to latent print examination, especially a challenge to accuracy of latent print examiners, you certainly want to bring these studies to the attention of the court. Another persuasive argument to rebut defense criticism is to research the number of latent prints using the ACE-V method, research the number of ballistics labs worldwide following the AFT process. How many DNA labs worldwide are using star mix? That last statistic you can find out from contacting the New Zealand government lab that develops star mix, ESR. It's a persuasive argument that wide or universal use of a particular discipline or technique or technology is evidence of general acceptance. For a Frye response about star mix, we listed other uses for Bayesian statistics and MCMC to prove these are well-accepted tools used in science and industry. And to prove that likelihood ratios were well accepted in science, we did a PubMed search and found literally tens of thousands of published articles about likelihood ratios in medicine and genetics and other industries and sciences. That again is persuasive evidence of general acceptance. Now, if you are defending a new technology, it would be useful to submit peer-reviewed journal articles. One thing we found useful is we don't necessarily expect that the court is going to read and understand the articles, but we would read them obviously ourselves and then provide a short digest of the article along with the article to the court. Obviously, peer review is an important indicia of general acceptance. Another thing that's useful is to describe presentations on the topic at various conferences. And there are a lot of conferences discuss forensics. All of the American Academy of Forensic Science, their annual meetings have a wide variety of disciplines. Ishii obviously talks about DNA. ISFG talks about DNA. They talk about probabilistic genotyping. Regional conferences like NIST often sponsors conferences where they discuss various forensic disciplines, and specialty groups like toxicology and other specialty organizations. These kind of presentations are relevant because there's a targeted audience of subject matter experts, people who work in the field. When you give a presentation, it generates conversation, it generates debate. It's the very fundamental kind of peer review. This also helps demonstrate general acceptance. Now, there is one legitimate criticism about feature comparison experts, and that is that they shouldn't testify that a match is a match to the exclusion of all other items in the world or to a 100% certainty. And that makes sense because no fingerprint analyst is able to compare every fingerprint of every person who has ever lived or who is living in the world now, and no firearms toolmark examiner has ever compared every piece of evidence and every toolmark to every firearm ever created. The uniform language for testimony and reports, these are on the DOJ website. They have reasonable limitations that do not dilute the significance or probative value of matched testimony. Your lab may want to agree to abide by these limitations. These limitations include not testifying to 100% certainty, not testifying that you've never made a mistake, not testifying that two things match to the exclusion of all the other like items in the universe. And another one is it counsels against testifying to a reasonable degree of scientific certainty unless your jurisdiction requires that particular set of words to get an expert opinion into evidence. Now, the newest assault on forensics features a new type of defense witness. These are not forensic practitioners who have reviewed the evidence and disagree with the government's conclusion, but these so-called experts are people with no forensic experience at all. Often, these are academics who have been appointed to panels to investigate the quote-unquote foundational validity of various forensic disciplines. They're often academics who have no connection to any forensic discipline at all, but nevertheless consider themselves to be experts. They sometimes publish or testify in a way that denigrates the role of the actual forensic examiner. And perhaps because they do not have forensic training and experience of their own, they specifically state that forensic training and experience are not important to accuracy and reliability of a particular discipline. Sometimes they also criticize the bench forensic practitioner for having skin in the game because they get paid to do their job every day. This, of course, ignores the fact that many defense experts get paid handsomely for their own testimony. Now, these are the government reports I mentioned earlier that many experts, defense experts, cite to throw shade on forensics. I've read them, so if you don't want to, you don't have to. So the NAS report was much anticipated. It was released in 2009, and many experts, defense experts, jumped on that and argued that the NAS report was a wholesale put down of forensic techniques. That is not at all true. In the very beginning, in the foreword of the report, the NAS committee said, the committee decided early in its work that it would not be feasible to develop a detailed evaluation of each discipline in terms of scientific underpinning, level of development, and ability to provide evidence to address the major types of questions raised in criminal prosecutions and civil litigation. So if you have a case where the defense has cited the 2009 NAS report, you should be certain to let the court know that the NAS report is not a repudiation of forensics. In fact, they do not do a careful examination of any forensic technique. What I have seen over and over again is the defense in firearms and tool mark cases citing the 2008 National Research Council ballistics imaging report. These critics cite it wrongly to say that FATM comparisons don't work. However, this report says nothing of the kind. The Ballistics Imaging Committee studied whether a database of test fires of every gun sold in the US or imported into the US would be useful in aiding criminal investigations. Ultimately, the committee decided this kind of database would not be useful. They had lots of reasons for thinking so. First and foremost is the fact that the database would contain only images or pictures of the bullet and cartridge casing. And the fact is that images or pictures are second best evidence, and it is not the kind of evidence that ballistics examiners use. They actually look at the actual evidence. They look at the shell casing or the bullet itself. They also pointed out that there were already millions of firearms in private hands that would not be part of the database. Finally, you don't want to discount the politics of gun control as a factor in deep sixing the idea of a universal firearms database. So my favorite for defense citations is the 2016 PCAST report. And the defense reads this as basically saying that all forensics are unproven. Now, the PCAST committee was made up largely of academics. There were few, if any, forensic practitioners on the commission. PCAST determined that they were going to investigate, quote unquote, foundational validity of various forensic disciplines. Foundational validity is a made-up term that does not have a lot of, or any particular meaning in forensics. It's important to note that all of the forensic organizations that were mentioned in the PCAST report filed written replies detailing all the ways that the PCAST report was wrong. These groups included the DEA and the FBI and ASCLD and AFTI and IAI. The Attorney General at the time, Loretta Lynch, made a statement that the DOJ would not follow any of the PCAST recommendations. Best of all, the DOJ issued a detailed report refuting the basic premise of the PCAST report. The basic premise of the PCAST report was that the pattern comparison disciplines, like fingerprints and tool marks, involve the science of metrology. Metrology is measurement, measuring features. And the DOJ report points out that pattern comparisons do not measure features, they compare features. They don't describe their conclusions in numbers, they describe them using words. The DOJ report is extremely useful because once you bring it to the court's attention, many judges will cite this in their decisions supporting forensics. In fact, the DOJ pointed out the reason for the report was formally addressing PCAST incorrect claims has become increasingly important, as some recent federal and state court opinions have cited PCAST as support for limiting the admissibility of firearms and tool mark evidence in criminal cases. That's the reason that the DOJ went to the trouble of doing this superb analysis. Finally, NIST came out with a draft report about DNA mixture interpretation, which generated enormous controversy. They literally Googled lab validations for ProbGen systems and found that only 8 labs had posted their validations online. NIST then concluded this must mean there was not sufficient publicly available data to independently assess the reliability of the ProbGen methods. After NIST released the draft report, by law, they are required to solicit public comments. And boy, did they get comments. The vast majority of the comments were harshly critical and involved the failure of NIST to request validations from the lab. The labs pointed out that most validations aren't published because they aren't novel. And they also pointed out that most labs are not going to post their validations online because the validations include the private DNA profiles of lab employees, because many times the labs use employee DNA to perform their validations. The labs also criticized that NIST recommended that lab analysts should opine about the significance of the DNA evidence on the witness stand instead of leaving that up to the jury. The letters containing these comments are all posted on the NIST website, and if you have to respond to a defense motion citing the NIST draft report, the comments from the smartest groups of people in forensic DNA are a good place to start your reply. And here's your response to defense critiques about various aspects of any forensic discipline, that they go to the weight and not the admissibility of the evidence, and the defense is free to cross-examine the prosecution's experts all they want. Finally, you have to research defense expert witnesses the same way you would anyone else. Knowledge is power. With any luck, you might win your motion on the papers alone and not have to do a full-blown evidentiary hearing. I hope that happens for you. I happen to have a whole host of sample Frye motions that I'd be happy to share if anyone needs them, if you want to get in touch. Poll question number 1, how can you demonstrate general acceptance for Frye? A, through peer-reviewed publications. B, by the number of labs using the technique. C, by approval by accreditors. Or D, all of the above. The answer is D, all of the above. If you are a lab analyst testifying, how can you help educate the court? A, invite the prosecutor to your lab so they know what they're talking about. B, testify or provide an affidavit explaining the science. C, describing your validation and error rates. Or D, all of the above. And the answer is all of the above.
Thank you, Melissa, for that great presentation. And we have some questions from the audience to kick us off.
Hello.
So our first question is, what do you do if you are not working in a lab, but you're a forensic consultant? So the caller says ISO 17025 is just for labs, but how about if you're just a consultant?
Well, I think your obligation to the lawyer who is hiring you is the same regardless of where you work. Typically, prosecutors work with the government lab, whoever did the testing. Sometimes we do hire private labs and we hire accredited labs. And so we're still working within the lab framework. If you are a private consultant and you have been hired by the defense, maybe not to retest the evidence, but to look through the government lab reports and point out failings or issues, or even just help the defense attorney craft questions to challenge the defense expert. I think you have the same obligation either way. I think if you are a private consultant, you're a little bit hampered because the critique of the that the prosecutor can make of the private consultant is that you don't work in an accredited lab, you're not being proficiency tested, nobody is looking over your shoulder, you're not having a technical review of your work or your opinion, and if you make a mistake, nobody ever hears about it because you do not have a QA or a QC system that documents nonconformities.
Great, thank you. Our next question is, in your opinion, should laboratories and prosecutors collaborate regularly? In other words, not just in preparation for a specific case. Should this be an ongoing collaboration?
I do think that there should be collaboration, and I don't mean this to sound like the prosecutor and the lab are in it together, ganging up on the rest of the world. We do have regular customer working group meetings with the various labs. In New York City, we work with two different lab systems. One is the NYPD lab system, and they do ballistics and criminalistics, controlled substances, and latent print. And then we have the medical examiner's office that does the forensic biology, DNA, some of the toxicology, and obviously all the forensic pathology. And so the customer working groups are excellent ways for the lab and the prosecutors to bring issues to each other's attention. We often, not often, but sometimes, unfortunately, there are lab disclosures that need to be made. The lab explains the problem or the error to the prosecutor, and then the prosecutors have the obligation of determining what cases are relevant, and then disclosing this information to the defendant and the defense bar. When there are new types of reports or new systems or new technologies being adopted, again, it's very, very helpful to have collaboration between the lab and the prosecutors. And one of the most important things that happens is that prosecutors have to be very careful to accurately state what the evidence is and what the evidence means. We do not want to overstate the conclusions. We do not want to have a situation where we are misinforming the court and the judge and the jury about what the DNA evidence means or the forensic evidence in general means. And that often requires lots of conversation between the lab and the prosecutor, mostly to educate the prosecutor so we don't make errors and create situations where cases come back because we have misstated the evidence.
Great. Our next question is, how would you encourage or incentivize collaboration between the legal and scientific communities when examiners and other laboratory personnel, as we know, have a heavy workload?
So that's something that we deal with. We do a lot of cross training. We will have prosecutors go into the labs to talk to them about issues, and we request a lot of training from the lab, continuing legal ed type training. I think the best motivation is to make sure that the lab partners are compensated for their work, compensated fairly, and that means hours spent preparing and training both ways should be recognized and made. They should be compensated, and those things should be considered for their continuing education credits as well. Teaching a class is a very valuable lesson in reinforcing the lessons that you yourself have to use.
Thank you. This next question's it's a good one, because I was also thinking about this when you mentioned explaining statistics in your presentation. So the question is, many people have trouble understanding or conceptualizing extremely large and extremely small numbers. How would you recommend lawyers and or examiners address this in their testimony with regard to error rates and statistical statements?
So error rates are tricky because I think there is still a lot of dispute over how we talk about error rates. Are we talking about the error rate in a lab? Are we talking about an error rate in a group of people who participated in a study? Are we talking about an individual's personal error rate? I think the error rate that most concerns us is sort of the false positive rate, and what's the likelihood that we got the right or wrong answer in this particular case. So I think error rates are very tricky to talk about when you're discussing this with a jury. If you're talking about that with a judge, you can explain the various conflicts about even what the definition of an error rate is or what the error rate should be in a particular case. Explaining statistics, I think gets harder and harder. I remember, in the good old days when we had in DNA, when we had the random match probability, we could, and we were talking about the rarity of a profile. We could talk about the, how many, the population of how many planet Earths would equal, 1 in 6 trillion or whatever your source attribution number was for the particular lab. Likelihood ratios are more difficult, and it's certainly more difficult to teach prosecutors what they should and shouldn't say when you're describing a likelihood ratio. And we basically have told our prosecutors to read the statement as it's written on the report. There's no freestyling when we're talking about statistics. And I think, we describe to jurors, that we're just describing, two different hypotheses, and we train the prosecutors and the analysts are trained to explain that as simply as possible. And I do think that jurors understand it in the context of an individual case. It's hard to explain generally, but when you are talking about the context of a particular piece of evidence in a particular case, and they have that context plus the rest of the evidence surrounding the statistic, I think that fact finders are doing a good job of getting it.
Great. Our next question is, as you had stated earlier, most of the criticism comes from academics and not practitioners. But how about in the case where you have an individual that straddles both of those worlds?
I would be, so there, I mean, I have met and spoken to people who have run labs, who do have expertise in a particular forensic science, and who also look critically at studies, and they can point out the deficits in a study and suggest changes. So I think that's very valuable for forensics, because we want to get the right answer. Nobody benefits when we get the wrong answer. Nobody benefits when we are imprecise. So I actually think people who have both of those skill sets are valuable participants in the system.
Great. And so the PCAST report it's a few years old now. How would you say that examiners still need to be up to date on its findings, and are they still getting asked these questions in court?
I believe that they do need to have some general talking points about the PCAST report. That they should know that it's obsolete. It was published in 2016 based on research that was done in the years before, and they should be familiar with the criticisms of the PCAST report. So I think that they need to have answers if they're questioned about it, because defense lawyers will ask questions in such a way that it makes the practitioner sound basically uninformed.
Thank you so much again for your presentation. We very much appreciate you spending your time with us today, and the presentation. The question and answer period was fantastic. Thank you again.
Thank you.